Yes, all are ready? Start. Having heard the learned counsel at a considerable length, we are of the view that no interference of this court would be warranted for directing the respondents to change the entry of her date of birth in the service record. Stop. The petitioner has failed to satisfactorily the entry of her date of birth in the service record. Stop. The petitioner has failed to satisfactorily show that she has not taken any advantage of the recorded date of birth. Stop. We had repeatedly asked the learned counsel for the petitioner as to whether she could have secured the certificate of matriculation in March, 1986, annexure P7, by showing her recorded date of birth as 26 January 1961, as there is a doubt that a student below the age of 15 years could not appear in such an examination. Stop. However, no satisfactory reply has been given by the learned counsel to the aforementioned persistent by the court. Stop. The more fundamental issue which surfaces in the instant case is as to whether at the time of entry into service the age of the person who sought to be appointed is a relevant circumstance or not. Stop. The aforementioned question has been considered by the Supreme Court in the case of UOI versus C. Ramaswamy 1997. Stop. In that case, Rule 16A of the All India Service Death cum Retirement Benefits Rules 1958 fell for consideration of their lordships. Stop. Holding that the aforementioned rule do not apply to the facts of that case, the judgment of the Himachal Pradesh High Court in the case of Manak Chand versus State of Himachal Pradesh 1976 has been overruled on the issue because the argument with regard to principle of estoppel was repelled by the Honorable High Court. Stop. However, the plea of estoppel has been upheld by their lordships, and the observations in this regard are discernible from paras 25 and 26, which reads as under: inverted commas, in matters relating to appointment to service, various factors are taken into consideration before making a selection or an appointment. Stop. One of the relevant circumstances is the age of the person who is sought to be appointed. Stop. It may not be possible to conclusively prove that an advantage had been gained by representing a date of birth which is different than that which is later sought to be incorporated. Stop. But it will not be unreasonable to presume that when a candidate, at the first instance communicates a particular date of birth, there is obviously his intention that his age calculated on the basis of that date of birth should be taken into consideration by the appointing authority for adjudging his suitability for a responsible office. Stop. In fact, where maturity is a relevant factor to assess suitability, an older person is ordinarily considered to be more mature and therefore more suitable. Stop. Over.